All right, welcome back to our final voting session of the day and the week. Thank the Lord. We are going to start off, so we're on the Law Enforcement Officers Bill of Rights, Senate Bill 627, and we will start off with council reading our first set of proposed amendments for the evening, which are from Senator Jackson.
So you should have been emailed a copy of this last night. You may have a paper copy on your desks. I'm not sure, but it's amendment number 658-773/1. It's number 658-773/1. So these amendments, I'll just go off of the reprint. No, this doesn't have the language that the committee's passed so far.
So this is the original?
Well, so it's amendments based on or added to the original. So it doesn't have the work of the committee so far on it.
Okay.
Mr. Chairman and Jamie, just checking, are you going to read it in toto and just we comment after or ask questions after, or are you going to do section by section and we can ask questions or comment each time?
Let's do this section by section, it's easier to digest, and then make those decisions at that point, just because it's, you read this long amendment and then you come back, you're like, I don't remember what was at the beginning.
Thank you.
So if we start at page 6 of the reprint, this is taking some of the existing language from LEOBR. It is related to political rights, providing that a law enforcement officer has the same rights to engage in political activity as a state employee. Also prohibits a law enforcement agency from prohibiting secondary employment and requiring them to adopt reasonable regulations that relate to secondary employment. It provides that a law enforcement officer may not be required or requested to disclose an item of the law enforcement officer's property, income, assets, or source of income, debts. This is subsection C on that page. Unless the information is necessary to investigate a possible conflict of interest with respect to the performance of the law enforcement officer's official duties, or the disclosure is required by federal or state law. And just so you know, I skipped over a little bit there, but it also provides that a law enforcement officer may not be discharged, disciplined, or demoted, or denied a promotion, transfer, reassignment, or otherwise discriminated against in regard to the officer's employment, or threatened with that treatment because the law enforcement officer has exercised or demanded the rights granted by the subtitle, has lawfully exercised constitutional rights. And then it actually strikes an existing provision. The bracket isn't bolded there, but if you look at item 2, after the word constitutional rights, there's a bracket. So the part of the existing law that provides for those protections in the case of disclosure of information that evidences gross mismanagement, gross waste of government resources, a substantial and specific danger to public health or safety, or a violation of the law committed by another law enforcement officer. Those provisions are being stricken. That also includes a provision that says that a law enforcement officer may not undertake an independent investigation based on knowledge of disclosure described in that paragraph. But then the bracket closes and the language continues that a statute may not abridge and the law enforcement agency may not adopt a regulation that prohibits the right of the law enforcement officer to bring suit that arises out of the law enforcement officer's duties as a law enforcement officer. A law enforcement officer may waive in writing any right or all rights granted by this subtitle. So I'll stop there.
Just I have a question on, so what, I've never quite understood the full kind of like range of this. So may not adopt a regulation that prohibits the right of a law enforcement officer to bring suit that arises out of the law enforcement officer's duties as a law enforcement. Can you help us understand that?
Trying to think of the best example,
Like specifically, why would this be, why is this here? I mean, because it seemed like you already have that ability, so I'm just trying to figure out.
I don't know. I think I'd kind of have to defer to the two members of the committee who have law enforcement background on that one. I'm a little bit of a loss.
Senator Carter, go ahead.
Mr. Chair, thanks for your question. I have a concern about this. I think it's problematic. What I'm reading, and I'm reading it from the interlineated bill, so I think it's the same as in the amendment, but it says a statute may not abridge a law enforcement agency, or a law enforcement agency may not adopt a regulation that prohibits the right of a law enforcement officer to bring suit that arises out of the law enforcement officer's duties. My concern is that statutes govern causes of action in Maryland. That's how we have causes of action in Maryland. And so to say a statute may not abridge a right to bring a suit, that's not, that statutes govern causes of actions that can bring a suit. And then the other part of it that's awkward, it says, and a law enforcement agency may not adopt a regulation that prohibits the right to bring a suit. I don't think that's something that has ever happened, and so that seems like a stretch. Anyway, I think that I don't even think this is in the current. Most of what is being put in here is an attempt to replace LEOBR, but I don't even believe it is. Okay, well, anyway, I think this is a problematic part. Not saying I agree with any other ones, I just think this one is problematic. I think it's just going way too far.
Senator Bailey.
So we need to go back in time all the way back to the 70s. And we need to understand why this was put in there. Because what was happening was officers were being discriminated against by their actual chiefs, and they did not have any way to actually defend themselves, because the chief and the sheriff could make the accusation, they could change things, and they could actually go, and they had a lot of power, and they had a lot of power here in the legislature. And so this was done through the legislature to put everybody on the same page, so that everybody's rights were taken care of as a law enforcement officer.
So I'm reading this section, and I agree with Senator Carter. It's awkwardly written. As I interpret this E, and it says a statute may not abridge, I think the word statute there is actually an ordinance. They're referring to like a county ordinance. Like Carroll County could not pass an ordinance that changes this bill, and the department cannot pass a regulation that changes what's in this bill. So I was just saying, so I would think we should amend it, say an ordinance may not abridge, or a local ordinance may not abridge, and a law enforcement agency may not adopt a regulation that prohibits the right of a law enforcement officer to bring suit that arises out of the law enforcement officer's duties as a law enforcement officer. Just that, and all that's saying is, if you can't pass an ordinance or pass a regulation that says, but the police can't sue you for this. Police can't sue the agency or can't sue the county for this. I mean, that makes sense that they couldn't pass something that interferes. I mean, it's sort of a belt and suspenders. I'm not sure why we need to say that, because if it's in these rights, then how can they pass it, right? I'm not sure how they could prohibit him from suing, but it seems like I was just saying, I think this, but they say statute, I think they mean ordinance. They mean like a local ordinance. Because you're right. I mean, Senator Carter's right. If we pass this, statutes are equal. So if we patch a statute that changes this statute, we just change the statute. But I think they mean a local ordinance by that.
Councilman Lancaster. Oh, actually, sorry.
Yeah, I mean, my read is the same as Senator Bailey's, but I'll just say it more explicitly. I think this was inserted to protect black officers. I think this was designed to allow for discrimination suits by black officers against their department and to prevent local jurisdictions from making employment contingent upon the right to give up that right. So if we want to preserve the right of minority officers to sue their departments for racial discrimination, which is something that is not foreign to us given the news of the day, this is the provision that allows that and makes sure that our local jurisdictions don't head that off.
Seek to abridge someone's right to bring a case for discrimination is unconstitutional. That would never be, it's not a thing that needs to be stated. It would never happen because it would be illegal. We don't allow that. So I just think, like many of what these amendments are, it's stuff that doesn't need to be there, and it's, in my opinion, just another way to rewrite the same thing that we're attempting to repeal. I think it's unnecessary, and I would ask that we would consider to not adopt that part.
You can waive a constitutional right. I mean, that happens every day. So what they're saying is you couldn't, as a condition of employment, say, yeah, if you want to work here as a police officer, you have to give up the following rights. And I mean, I think that would be a legitimate thing that, you can say you can give up your right not to have a drug test, your right to all kind of rights. You can demand they give up as a condition of employment, and they're just saying you can't.
State law for like the fact that no other place in state or local law had the need to put this in makes me concerned that once again it's separating out police officers, giving them some special set of rights versus everybody else.
Yeah, but you're ignoring the history of racial bias that these police officers encountered in the 50s and 60s as they broke into the ranks.
And continue to encounter, like discrimination.
And continue to encounter. Okay, I'm just saying, I'm saying when
having
the
an LEOBR did not prohibit discrimination. You know what I'm saying? Like there was discrimination then, and there's still discrimination.
My understanding was it was a pioneering law that was brought, a lot of the LEOBR was motivated because you had black officers who were rising in the ranks, and they were being thwarted in that throughout this state. And so LEOBR, a large part of incentive behind LEOBR was to prohibit that subtle discrimination, as each county had their own processes, each municipality had their own process for how they treated different officers, and to protect them so that they would have a uniform process by which all officers went through for discipline, and this is just a part of that.
All right, Senator Sidmore and then Senator.
Thank you. And I was just going to say to Senator Carter's point, when I look at the title of the bill, it's repeal and procedures for discipline. And I think what she's getting at is this section has nothing to do with discipline, whereas the rest of the bill does. That's simply put. So I think, and I'm not trying to put words in her mouth, her thing is it doesn't belong here, number one. And number two, most of this stuff is, I think I heard her say that it's already, those rights are already in existence. So that's it.
I was just going to say, the hard part of what we're trying to do, if you look at the section, a lot of the citations are 1957, 1968, and so trying to figure out the case law of why this was in there or why not, and I'm trying to research that now. I mean, some of them aren't totally clear, but this is years and years of work that was put together the statute, and I always thought, just quite frankly, that there's nothing in 3103 that, quite frankly, I don't know that's offensive, and also that what was talked about are the issues with the OBAR as far as discipline or police misconduct. There's nothing in 3103 that applies to that. I mean, these are just rights, and they came about years and years because of actual incidents of discrimination, incidents of mistreatment. And so it's a long, well thought out, and, you know, it gives me pause to strike things that have, well, quite frankly, put in there for a reason. There's tons of case statutes from, quite frankly, 1957, 1958, when there were, especially during times where there was a lot of discrimination. So it gives me pause to strike that, especially because the things that we were talking about, the issues with the O-Bar, are not built around this section.
The amendment we'll consider right now. Discussion seems to have ceased. So there's been a motion. So it's been to strike it from the amendment, to not adopt, to strike.
Strike what?
Move to not adopt that section.
The whole section. Oh, E.
Section E. Subsection E, rather, yes.
Unfavorable motion.
Says an unfavorable. All right, it's been seconded, so you can roll it. To not adopt.
Vice Chair Waldstreicher.
No on the unfavorable.
Senator Lee.
Yes.
Senator Cassidy.
No.
Senator Heddleman.
Yes.
Senator West.
No, I'm confused. This was a motion to strike E,
Subsection E, the right to sue.
so if I vote yes, I'm voting to strike it.
Yeah.
All right, yes.
Senator Sidnor.
Yes.
Senator Jackson.
No.
Senator Bailey.
No.
Senator Carter.
Yes.
Senator Huff.
No.
Chairman Smith.
No on the unfavorable.
Adopt 3-103, the tire section.
I would like to.
Hold on, I got a motion.
Okay. Yes, I object to adoption of the entire amendment. There were a couple of other sections that, well, actually.
We're just going section by section, so we can talk about it right after this. Is it on this one, on this section?
Which one are we on?
3-103. It's just the political activity, which also encompasses the right to sue,
Okay.
and
No, I'm done with that section.
anti-retaliation. Okay. All right, so it's been seconded. It's been motion for favorable. Roll call.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Can you come back to me? Thanks.
Senator Cassidy.
Yes.
Senator Heddleman.
No.
Senator West.
Yes.
Senator Sidnor.
No.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
No.
Senator Huff.
Yes.
Senator Lee.
No.
Chairman Smith.
Yes. All right, let's go on to the next section. So the amendment carries, passes.
That's right. So on the next changes on page 7, In lines 5 and 6, there are some technical changes. And then lines 10 through 12 relate to the investigation of misconduct. And it provides that, as it did in the bill, or does in the bill as it was introduced, a sworn law enforcement officer or a person who is not a sworn law enforcement officer may perform the investigation of misconduct. This adds language that the person who is not a sworn law enforcement officer would need to receive training administered by MPTSC on the investigation of misconduct committed by law enforcement officers.
Just a question. So does such training exist already, or do you have to?
No. So it actually, at the back of the amendment, provides for MPTSC to develop the training program.
Okay, so this training, usually you have, like, so for the civilian boards, you have training to be on the board. Training already exists, good to go. This is separate training for basically participating and or leading an investigation that has to be developed by the Training Standards Commission. So I guess the policy reason behind this is to ensure that, I'm opining, so yes, all right, Senator Jackson, yeah, help us out.
Well, if you recall, so we are moving to a 3-person board where you have 2 civilians and a sworn officer. So in order to have those 2 civilians to, to legitimately sit on that board to hear cases dealing with police policies, they need to get that training.
I get that, because we did that last with Senator, like initially, we made it so that if you had to sit up, we put 2 civilians on the board, but to sit on that board, you had to have training. So we did that last time. But this is different. This is for investigations, right?
That's correct. So this would be the investigation piece. The civilian training is covered later in the bill, but this is just on the investigation piece. So in order to be an investigator, the person would have needed to have received the training if they were not otherwise a sworn law enforcement officer.
So not currently. So you could have been a former officer, but you still have to go to the training.
I suppose that's true.
Okay. All right. Do you want to do a roll call, or is everyone okay? It's page 7, lines 12 and on. Subsection 3, Roman 2.
So line 12 up to...
Just do the underline.
Just the underline.
Yeah. So the amendment is adopted unanimously. Okay.
So moving on to page 8 of the reprint, these are the provisions that relate to the investigatory file that needs to be provided, investigatory file and any exculpatory information that are required to be provided to the law enforcement officer. As it's drafted as introduced, the chief would be required to provide the law enforcement officer with a copy of the file and exculpatory information if the officer and the officer's representative agreed to execute a confidentiality agreement and pay a reasonable fee. The bill provides that if the investigative file and exculpatory information could not be provided, that the chief or the chief's designee would provide the officer with a written summary of the facts and evidence used as the basis to conclude that the officer committed the offense or offenses. So what this does is it strikes out the requirement that a fee be paid and also strikes the provision providing for the summary to be provided in lieu of the investigatory file.
So that amendment is adopted.
If you turn to page 16, this provides for expungement. This is just under line 9 of the reprint, page 16. This provides for expungement. It alters the existing expungement provisions from LEOBR. It provides that on written request, a law enforcement officer may have expunged any file from any file the record of a formal complaint made against the officer if the officer or the law enforcement agency that investigated the complaint either exonerated the law enforcement officer for all charges in the complaint or determined that the charges were unsustained or unfounded, and at least 3 years have passed since the final disposition by the law enforcement agency. It also provides that evidence of a formal complaint against a law enforcement officer is not admissible in an administrative or judicial proceeding if the complaint resulted in an outcome listed in A1. So that is the exoneration or determine that the charges were unsustained or unfounded. It strikes a provision from the existing LEOBR that allows for expungement of files if the matter went to a hearing board and the hearing board acquitted the officer, dismissed the action, or made a finding of not guilty.
Thank you, Mr. Chair. I'm a little confused. So this, as written, says that the complaint must have been the officer was exonerated or the charges were unfounded, but it has to be the agency that did it, and then you've stricken out the stuff about the hearing board. So if a hearing board found the officer the charges were unfounded and recommended dismissal or recommended I'm not sure what they recommend, not guilty or whatever the recommendation is, consistent with unfounded charges, could that be, does this permit that to be expunged, or is it only if the initial investigation found that the charges were unfounded that you get that expunged?
This is that if it went to the hearing board, then it would not be eligible for expungement. If it went at all, it would need to take place prior to the hearing board.
So if it went to a hearing board and the hearing board concluded that the charges were unfounded, the officer could never get that off his record?
Well, I think as it works now, at the hearing board stage, it's either a guilty or a not guilty. So, right, in the situation that you just described, right.
And then the police chief, so if the police chief accepts the recommendation of the hearing board and finds the charges are not meritorious and therefore the officer is not guilty, that record never leaves his record. He has to live with the fact that he had a hearing and the charges were pressed against him for the rest of his career.
Right, it provides for that it would need to happen at the investigative stage, that determination on exoneration or it being unfounded needs to have happened before that.
So can I turn to the maker of the amendment and ask why we're going to allow charges that are found to be unfounded at the investigatory level can be expunged, while charges that are found to be unfounded at the hearing level cannot be expunged?
Thank you. Well, I think part of what we're trying to do is, so part of the challenges that we've had is, we did it with MPIA. How do you get to records of a person who got multiple complaints in an agency? If those complaints within that agency didn't rise to the level of a hearing board, then I think that's what the public is asking for. You allow them to have that. There's already a record of the hearing board findings. That's in the agency. So if I were tried within my agency, if I had to go before a hearing board, there's a record of that. I think what we're trying to do is to make sure that if a charge was if a charge was made on an individual, didn't rise to the level of a hearing board, public wanted to get that information, they could have that information.
So, if I understand this correctly, then it seems to me, and I think I hear what you're saying, Senator West, is that it's odd that if it's just dismissed outright without an actual hearing, which means they would have gone through less scrutiny, then it is expungible. But something that's been heavily scrutinized, and then a determination of not guilty has been made, then that and the records that are associated with that thorough, in-depth process can never be expunged. Is that the way we're reading this? Just because having gone through the hearing process, you're not eligible for expungement?
Right.
And that seems like, if that's true, it's kind of backwards, but.
Be able to do that. I guess we're flipped in this amendment here, Jamie. Yeah. We need to straighten that out.
Thank you. I have a question. First, what other agencies allow allegations to be expunged? And I ask the question because I don't know. And the second thing is, if it's unfounded, it's still in the record. It's unfounded, and we already know that there's no prohibition on officers that have complaints, whether founded or unfounded, from being employed in other agencies if they want to move on or be transferred to someplace else. So my question is, how is this similar or different than every other public employee? What other group of employees are allowed to expunge records of allegations?
Pull that up in just a sec. I'm going to do a quick search, Senator, and I think I may have something in mind, but if you give me just a minute.
Well, I don't want to take you to another second part. The second part is the part about the rules of evidence. I have a concern about that. I think that's highly irregular and inappropriate. I think that we already have rules of evidence, and we've already discussed in this bill and other bills how courts use strong criteria to determine whether or not allegations or someone's potential bad acts can be admissible. And so I would argue and posit that should absolutely not be included. And that part of this amendment should definitely not be included. And why? Because it definitely puts law enforcement officers in a different category of every other human being and every other employee, in a different evidentiary standard than everyone else, and I think that's highly inappropriate. It has nothing to do with discipline.
What line are you talking about?
So she's talking about subsection B. It's like right above line 10. So on page 16 of 17, it's evidence of a formal complaint against a law enforcement officer is not admissible in an administrative or judicial proceeding if the complaint resulted in an outcome listed in subsection A1 of this section, which then refers up to exonerated, unsustained, unfounded.
I think it was last year or the year before, this legislative body actually passed an exception to the rules of evidence in the other direction, for people that certain people accused of certain crimes that had certain allegations of bad acts that they were never convicted of, in order to ensure that these potential allegations that were never found were able to be, the court could possibly use them against them. I'm just saying this is a extreme reversal in the other direction, and I would strongly urge us not to make this exception.
You're saying that,
So, Senator, I did find an example of expungement in the State Personnel and Pensions article for expungement of employee records. There's an example where if on an employee's appeal to an agency head, the agency head issues a decision to rescind a disciplinary action, within 15 days after the decision to rescind, the action shall be expunged from the employee's personnel records.
It looks remarkably similar to what's already in. Looks like the LEO copied that section. It looks exactly the same. Almost. It's pretty close.
I think as the bill came in originally,
Yeah.
right. Right, that's the new language
Yeah.
from the bill. There's also a provision in 11.110 of the State Personnel and Pensions article that provides for expungement of certain other records when an appeal is undertaken.
I've always supported a lot of the expungement laws. I mean, in fact, I voted for it. We just did I think it was 3 years ago. We changed the law to allow expungements for citizens and acquittals, found not guilty, dismissals, probations for judgment, no pros, debts, not criminally responsible. We just added all those in, which matches up pretty much well against this. And so the idea of how we treat one group versus another, well, since we dramatically expanded MPIA and we had a big argument over that the other day, it seems the public will now have access to a lot more files. And here we're saying, treating them like a regular citizen who we expunge it. If you go to court, if you're charged, you're arrested, you're charged, if you're arrested and you're charged, and you go through the process, and the court acquits it, dismisses it, gives you a PBJ, which is not a finding of innocence, as you pointed out the other day.
You're arguing for no reason. Jamie answered my question.
No pros. So no, I'm not arguing because I want to strike. My motion is to strike the brackets and to restore the section how it originally was.
So on page 16 of 17, your motion is
To strike the brackets and restore it how it originally was.
To allow for expungement in the context of
Yeah,
when the matter
that
goes to the
in
hearing
cases
board.
where the hearing board dismissed the action for finding of not guilty. I think that is totally fair that be in there, and that is consistent with Maryland's expungement law, which.
Senator Jackson, do you want to say?
Yes, I'll second that. I mean, reading it, I should have read it before, but.
I just want to say that I'm not going to disagree, but I just think that it's apples and oranges. I mean, I think what Jamie answered is definitely more akin with what I was asking, because I'm talking about employees and administrative proceedings. This is not the same as a citizen charged with a criminal offense. This is about administrative proceedings. Jamie satisfied my question, but I don't think it's accurate to compare these to criminal cases.
Is everyone okay with that, or you want a roll call? All right, we'll do. All right, looks like all right, the motion carries.
Mr. Chair, I make a second motion
Sure.
to adopt this section in whole.
So the section that's been,
Adopt the expungement section in whole now.
so that's,
3114.
yeah, and all the way down. So hold on, let's explain it first, and then we'll vote on it. So he just wants to restore this entire.
Sure. You want me to walk through?
Yeah, please.
Okay. So this would now provide that a law enforcement officer may have expunged from any file the record of a formal complaint made against the officer if the law enforcement agency investigated the complaint and exonerated the officer of all charges in the complaint, or determined that the charges were unsustained or unfounded or a hearing board acquitted the law enforcement officer, dismissed the action, or made a finding of not guilty, and at least 3 years have passed since final disposition by the law enforcement agency. Just to note for the committee, you'd also be restoring the bracketed out language "or hearing board" in paragraph 2. It would also provide that evidence of a formal complaint against a law enforcement officer is not admissible in an administrative or judicial proceeding if the complaint resulted in an outcome listed in subsection A1, so that is the exoneration, determination that the charges were unsustained or unfounded, or the acquittal, dismissal, or finding of not guilty by a hearing board.
Put back in then. Okay. So they also have to find that the charges were not, they acquitted the law enforcement.
You put the mic closer to you, sorry, so we can all hear. The mic closer to you.
Oh, I'm sorry.
No worries.
I should have raised my hand. So it means that the hearing board, composed of the 2 civilians and a law enforcement officer, if they acquitted the law enforcement officer, then he can get expunged, or this.
That's right, but see, as we've drafted
put
it.
back into the bill then, okay.
Yeah, but as we've drafted it, we don't have to go into it, but
Okay.
they can't, there's a recommendation that's recommended, so it's,
I mean, their recommendations,
Yeah.
they found that he was not guilty, or he was.
as it's drafted right now. Okay, Senator, do Senator Sidnor, then Senator Carter.
I think that was the question, what my question touched on was this whole made a finding of not guilty. I think that has to be wordsmith because I thought they're giving recommendations versus making findings.
So the facts are binding, and there's a question as to whether, if there's a finding of not guilty, whether that is an actual decision, which is binding. So I think we're going to have that discussion later on tonight. So we don't need to revisit this just yet. But you're right. Your question's right, because the board is making a non-binding recommendation otherwise. So go ahead. Correct me if I'm wrong.
Well, just the term guilty or not guilty actually isn't used in the bill or in the amendments that the committee's adopted. So that
it's my colloquial explanation for founded, unfounded. All right.
It's sustained and unsustained.
Or sustained and
I think it's violation of the policy.
It says right, the amendment says finding not guilty.
well, right, the amendment does, but as far as the hearing board procedure, right.
That's he'll.
They would, once you put this in the law, they're going to have to say, we find not guilty, or it doesn't comply with this. They'll figure that out. And then the fact finding is going to be binding as long as we do what we did.
Got it. You're right. Okay, you're right.
We shouldn't overthink that part, just to be honest. And if the hearing boards don't get
Just,
it.
I don't. We should. I don't want to confuse the argument right now. So, because we're going to come back to this in a second. So, I was just trying to give explanation to Senator Sidnor's question. At this point, it almost doesn't matter until we go to this other part later, which will be addressed in a forthcoming amendment. So we'll have this discussion again.
So what's our plan with this amendment here?
There was a motion.
A motion, a second, to adopt the thing in whole.
Yes.
Okay, I have amendments I'd like to discuss before you move forward with adopting the thing in whole.
Your amendments to this section?
Yeah, to this section.
This is restoring the original law.
No, it's not. No, it's
Okay.
not. No, I mean, I just tell you what it doesn't do, real quick.
Got it. Real
Okay.
quick. Okay.
Yeah,
Go ahead.
yeah. So what, some of the big things that are left out are that, first of all, on page 6, I'm sorry, I guess it would be 6A, it's not numbered. Section 3105.
Hey, sorry. Hey.
I'm on the
Senator
amendment.
Castley, we're on page 16. We're on section 3114.
Okay, you were just moving
Just
the
that small
entire
piece.
amendment in.
Just the expungement piece.
Okay,
Just that
sorry,
small
The way you
piece.
said that was the whole amendment.
No. I'm sorry. Just that was the entirety of his suggestion, which is the amendment that you want to draft.
Okay, so which one is that now? Got it.
3114.
Okay.
Just
that's
from
fine.
line 9 down to 10.
And we've already voted to remove the bracket
So you want to restore
Gotcha.
that.
Right.
The second motion then is to vote the whole thing through, which is a restoration of what the expungement statute was.
Yeah, okay, we're fine with the expungement statute.
Yeah.
I thought we already adopted that one.
No, no. We
We only adopted removing.
The brackets, okay,
Brackets.
all right, I'm sorry, I misunderstood what you were saying. Go ahead.
got it. All right, Senator Carter.
So I've just heard two different things. I've heard a motion and a second to adopt the whole thing, and then I've heard we're only talking about the expungement. So does that mean we're including or excluding B, which is the evidentiary standard?
The motion was. The first motion which passed was to remove the brackets in 3-114. My next motion, which was seconded, was to adopt 3114.
Then I'm going to speak against the adoption of that section before we vote. I think that's the poison pill for that is the fact that it sets up a different evidentiary standard, which I've already talked about. I think that's wholly unacceptable. And, I could consider it with striking B, but keeping B in, it makes it a poison pill. So I'm going to urge the body to reject that motion if we're going to keep B in.
Okay, I definitely want to hear more about that. So Senator Cassidy, and then I'll come back to Senator Carter. We'll talk a little more.
So, I'm just trying to understand what this says and what your position. The way I read this is, if I'm a police officer and there had previously been a complaint against me because I neglected to maintain my car, and that was back a year ago, and now the charge is I neglected to maintain my car, that you think they should bring in the evidence of the previous one that on a year ago I didn't maintain my car, so I'm probably guilty the second time? Because that's what I hear you saying, and I'm like, it's not registering. What's
know that you know that, because I know that you know a lot about the rules of evidence in these judicial proceedings. I'm saying that I want to liken officers' allegations to everybody else and let a court decide whether or not anything from the officer's past is admissible or not based on the court's standard test that they do when it considers prior acts or bad acts or potential, other evidence of things that they may have done or may not have done, and the court will make the determination. But to say there's a blanket prohibition, if there's ever been an allegation against an officer, it could never be used in a judicial proceeding. I think that is exactly the type of that's exactly the type of thing we need to legislate against. So that's what I'm saying. I'm saying don't separate them out, or if we're going to do that, then let's just put it in for everybody else. That, no court can do that for anyone if they can not do it for officers.
I mean,
that's
the
what I'm
prior
saying.
bad acts exception is so limited. I'm not, this is like saying you were charged with burglary last year, now I'm charging you with burglary this year, so I get to bring in the fact that, hey, we charged her last year, so she's probably, hey, she probably did it last year and didn't get convicted, so we're going to bring in this year and we'll prejudice the fact finder.
And body that voted that if someone had a prior sexual allegation that was not ever, they were never found guilty of, but they were accused of another sexual offense, that could
But it was very
be
limited and had a whole lot of conditions
But
upon
my
it.
point
It was
is
very
that
controversial.
I don't think we should make exceptions one way or the other. I think we should let the regular rules of evidence decide and let the court decide whether something should come in or not. It's not for us to determine ahead of time what a court can consider and what a court cannot consider.
But just for the committee and for those listening at home, this section does not disallow the underlying allegations from coming in where they are otherwise allowed as evidence of prior bad acts or by the court. It only disallows the allegation file, the allegation that the record is held by the police from coming in. The person who made the underlying allegation is still allowed to testify in court if that testimony is allowed by prior bad acts testimony. The court can still allow it. It's not the allegation that's not coming in. It's the evidence of a formal complaint. It's the complaint that can't come in, not the act. The act, of course, can come in where otherwise allowed by law. They're not trying to keep out what happened. They're trying to keep out hearsay complaint of of what happened. If that person has evidence, that person is allowed to bring it in. And I just wanted to clarify because I think that got a little lost in the debate.
It also is clear that what's not allowed in is if it has an outcome listed in A1 of this section. An outcome listed in A1 of this section is that he was exonerated and determined that the charges were unsustained or unfounded. So how could you possibly bring in you're going to walk into this administrative hearing and say, well, officer, you were charged with the same thing a year or two ago, and it was found unsustained, it was unsustained or unfounded. And I just want to get that in the record to prejudice the fact finder because, hey, once a dirtbag, always a dirtbag. I'm sorry, I'm just like, how could that possibly, it just makes sense to me that you wouldn't bring that in. I can't imagine a circumstance that you would allow unsustained or acquitted findings to come in a subsequent hearing.
And about a potential judicial hearing, it could be a criminal or a civil proceeding that's outside of the administrative arena that this is here.
Complaints, it doesn't apply to criminal laws or criminal conviction. It applies to administrative complaints that were exonerated and determined and the charges were unfounded, an administrative complaint.
Why does it say or a judicial proceeding?
It says it's not admissible in administrative or judicial proceeding.
Correct. Anyway, I think that's for the court to decide. I don't think it's for us to decide, so I'm not going to support it. We don't have to continue to debate it. I think it's wrong for us to do.
I was just going to say, I think we're ready. But the last thing, I had a lot of heartburn on that bad acts. And I asked a lot of hard questions a long time. The bad acts, that was about, you could even, about bringing in prior, allegations, prior convictions. The whole idea is
Convictions, it was allegations.
Yeah, I know it's mere allegations, but you're not even, when you, I'm totally with you on the bad act stuff. I have a lot of concern about what was done in the law there. In that, the idea you could bring in convictions, allegations, you're supposed to judge an act by the singular act. You're not supposed to be, even if you had 3 prior assaults in this country, it doesn't mean you did the 4th assault. The 4th assault is a charge of a single act. Well, it's just saying this is actually very similar to the bad acts. It's saying a police officer, just because you charge him with something down the road, doesn't mean you get to bring in mere allegations and not guilty findings to use them to convict him in a further proceeding. This is actually the definition of bad acts of why you charge on a single incident. So
No, you charge on a single incident. But what happens is that there can be exceptions to that bad acts where, as we've made a decision to do with the sexual crimes, not even crimes, sexual allegations, where the court can look at the fact, well, hey, they weren't founded, but hey, there's been 15 allegations
but the law that
of
you're
sexual
arguing,
assault.
the law that you're arguing against, you are arguing to do the same thing with police here. You're arguing the same thing, is to bring in not guilty findings, to bring in allegations,
You all
and to
passed
further.
a law to do that for other people.
I just told you there were structural problems with it. I'm not sitting here defending
I
bad
didn't
acts.
agree with that, and I don't agree with this.
Well, you should agree, because this is the same principle as bad acts. What you're arguing for expungement and bad acts is the same for
I'm
police.
simply saying you let a court make a determination based on the information. The court has to be able to have access to the information to make a decision.
Could you give her back there, Senator Carter? All right, there you go. So hold on, we got Senator Bailey wants to get in on this. Appreciate the spirited debate. Let's keep it going.
All I was going to say is, when we're talking about this from a prior complaint, we're talking about an administrative complaint. That administrative complaint deals with hearsay evidence. It doesn't have the rules that apply in a criminal court. It shouldn't be allowed.
I just want to reemphasize, like Vice Chair Wallstreaker's point. The complaint can still be brought in or weighed under the rules of evidence. It's just, like you said, the files, and it's something associated with it. So I got it. Okay. Sorry, Senator Lee, and then we're gonna.
Okay, because I'm totally confused. So, a prior complaint, even if it was proved unsustained, cannot be brought up in a judicial proceeding later? Like if you have a cause of action later, you can't say that there was a prior complaint against this officer? No, yes?
Again, as Vice Chair Wallstreger pointed out, which is just in lines, like the last, like literally
But
two
you
lines.
can't, you can't show in a subsequent judicial cause of action.
You could still bring-
Can you say, well, this officer had a complaint of this against him?
Well, that would be weighed. I mean, it wouldn't be, that
So
would.
they cannot do that
You can't bring
then?
I can't hear what she's saying. Can you?
Yeah, okay, so if you have another, if there's a cause of action brought against this officer, you could not bring up the fact that there was a complaint against him? Yes?
Itself, like you said, can you explain to Jamie?
But
that
there
it's
was
the
a
actual,
complaint
but all the
against him.
facts that led up to it. Like, yeah. Yeah. If I'm not answering it correctly,
Can
go
you,
ahead.
can you answer that, Wallstreger? Okay, I mean, Mr. Vice Chairman, excuse me.
Wait, what's the phrase you just used? The underlying facts of the case that gave rise to the complaint are 100% admissible. If you were maltreated by a police officer, the fact that you filed a complaint does not prevent you from filing a civil suit and repeating in any context what happened to you in court. That is 100% admissible.
But in that suit that you bring, could you say that Officer A had, there was a complaint brought against him? Could you bring that up in the subsequent judicial proceeding under this?
No. I think the answer to your question is no.
Is no.
I'll defer to counsel
Okay.
here. But I think the answer is no.
Forever, right, okay.
Motion's been made for a favorable, it's been seconded. I think this is a roll call.
Vice Chair Waldstraker,
Yes.
Senator Lee,
Come back to me, okay, thanks.
Senator Castle.
Yes.
Senator Huddleman,
No.
Senator West,
Yes.
Senator Sidnor,
No.
Senator Jackson,
Yes.
Senator Bailey,
Yes.
Senator Carter,
No.
Senator Huff,
Yes.
Senator Lee,
No.
Yes.
Chairman Smith.
Yes. So it carries.
Three 114, the striking of 3114. Or, what the?
Oh, sorry.
Oh, sorry,
You're right, you're right.
3115. I'm
No,
not
you're
sure
right,
what-
you're right. Keep going. You're right.
14
Yeah.
through 20, 14 through 30. It's on page 16 of the reprint, lines 14 through 26, and then flip the page, and it's lines 28 through 30.
So this is the provision of the bill that authorizes a county or political subdivision to adopt a local law or ordinance that establishes an oversight body to, actually subject to earlier amendments by the committee. It was to decide disciplinary matters and impose disciplinary action for law enforcement officers that were under their employment.
Well, I disagree with this. Let me just say, speaking to this section, we can have different philosophies about the oversight of law enforcement, and surely we do. But I happen to believe, as I've said many times, that law enforcement work for the people that they serve, the people that pay their salaries, the taxpayers. And it is illogical that we've set up a system that has not allowed, up until now, people that are supposed to have some type of say in how policing is done in their jurisdictions and some kind of say in how discipline is done. We've not allowed them to participate in that process. And so this section of the bill, to me, is critical. It is only enabling. It only says that if a jurisdiction wants to set up its own civilian oversight entity, that they have the ability to do it. It's not taking away from anything that we've done here, but what it is it's sending a message to the constituencies that we've heard from since September and that some of us have heard from 10 years or more, and showing them that we are no longer giving deference to law enforcement in a way that keeps them out of the process. I don't find it acceptable that we would strike this from the bill. It's really, frankly, it's appalling. It's absolutely appalling that we've now allowed, in a bill that is labeled the repeal of the Law Enforcement Officer Bill of Rights, we've now restored all of the things that are unnecessary in the bill, which completely guts the concept of repeal of a Law Enforcement Officer Bill of Rights. This was all about saying that we are no longer going to tell the people of Maryland that we say this one group of people that has the ability in a fleeting moment to kill you like nobody else does, like no other group of people, like not even a judge can decide or a jury because we don't have a death penalty. We have now said that you can't have any say if your jurisdiction wants you to over that disciplinary process. Yeah, I know we allow citizens on a trial board or a hearing board, which is a one little cog in the system, but it is not giving them the great latitude that they ought to have, that they're entitled to. And so, to be honest with you, if you take this out of the bill, I don't think that the bill has very much value. So I'm going to really strongly urge everybody to oppose this amendment.
So I think it was Monday. I think I proposed an amendment, and part of my amendment was to take out 3.110 and 3.114. And the reason I asked for 3.114 to be stricken is because I also made the amendment for us to have 3 people on a board, and 2 of those 3 people are civilians. So to say that civilians don't have a say-so in this, I'm not sure what that means. I mean, typically a person from law enforcement would probably say they need to have more law enforcement than civilians on the board. This is an enabling piece of legislation, as you say, or a proposal or provision. And I believe you've said in the past that this would take 5, 6, 7 years, maybe more, before this were up and running. I made the suggestion the other night, if municipalities or political subdivisions decide to do this, when you have there are some commission forms of governments that are putting forth different pieces of legislation for oversight boards or civilian review boards, and they're doing it county by county, or I guess in your case would be the city. But I just wanted to say that we have a board of 3 people that are going to be making the decisions. The public has input. These are people from the public. They're not uniform officers from that agency or from another agency. 2 out of the 3 are civilians. I made that amendment proposal. You voted for it. I think this is duplicative. I'm not sure that we've been talking about what belongs in the bill, what doesn't belong in the bill. I'll stand by my amendment.
I thought this is one of the worst provisions in the bill. We spent all this time setting up one system. We heard there were disparate outcomes. We heard the differences, that we needed one system. That's the whole point of the law. We're spending hours and hours arguing over what is the one system. There was an amendment. I was on the losing side. The prevailing side was to go to 2 civilians, 1 officer. That's the system. But now you're talking about, well, that's the system unless the county wants to do another one. And I'd say for all those that want more discipline, you might not get what you want in more conservative parts of the state if they set up their own civilian boards. You may not get the outcome you want. And for those of us, the best way to get a singular fair outcome is a singular fair law. And if you look at the law now, not only is it 2 civilians, and to act as if this does nothing, what we've talked about here, the amendments that I've been on the losing side on this thing, when 2 civilians, 1 police, but not only that, the law takes all the internal, all the administrative stuff the chief does. Chief has total latitude now over that. The board with the 2 civilians is just dealing with the public stuff. And it totally eviscerates collective bargaining, their separate agreements. I mean, this moves it way farther. The act as if this does nothing. This is a crazy section. I have no idea why this is in there that says you all spend hours and hours coming up with a state law. By the way, just let the counties do whatever they want. And the idea that you're going to get fair outcomes that way, the idea is that we don't have disparate outcomes. How do you think a civilian review board is going to be the same in Montgomery County as in the same as in Allegheny County and the Eastern Shore? If you want fairness across the board, that's why we're debating a state law for this. A state law for disciplinary actions of officers. We're not, here's a state law that we spent hours and hours debating, but hey, counties, go do whatever you want. I think that is a terrible idea.
Yeah, I would just say that we're not here to make statements. We're here to make public policy. We're here to make wise public policy. Not to appease people, but to make wise public policy. Not to assuage public anger, to make good public policy. If that assuages anger, that's awesome. If that doesn't, it's wise public policy is what we're supposed to do here. And quite frankly, this provision at the end, I was reading through, the first time I had this bill, I'm reading through it, I'm like, I need some changes. We worked our way through it. I got to the end and I was like, what, are you kidding? Are you kidding me? What is this? It was shocking. It was just terrible public policy. So I just totally reject the idea that, oh my gosh, if we don't adopt, this literally makes it a kangaroo court. This literally makes police discipline subject to a kangaroo court, and that's preposterous. So this was really bad public policy. It's got to come out. There's no way we could adopt a provision like this. It undoes everything that we tried to do with this bill, which was to have a uniform, organized, well-structured disciplinary policy that was fair and open and transparent for all police officers throughout this state. And then to pitch it back to the counties and say, now make up something else, is just totally contrary to everything we're trying to do. So, thank you.
All right, so has there, motion second. All right, there's been a motion seconded. I suspect we'll do a roll call. Just hold 1 second while we get, yeah, we'll just get 1 second.
Promise this is going to be brief. I've got to take exception with the contention that I'm not about trying to make good public policy. I just happen to believe that public policy doesn't negate the public having control and say over the disciplinary processes for the law enforcement officers that they hire to protect and serve them. So to contend that bad public policy is giving the people more power and more control, I think that's highly offensive. And then to criticize, my desire to have that done as bad public policy, it's really appalling.
Excellent. Thank you for that. Thank you for saying that. All right, so roll call.
Vice Chair Waldstraker.
Yes, and just to explain my vote briefly, I actually agree with everything Senator Carter said, but, you know, we kind of talk about values in poetry, but we govern in prose, to steal Mario Cuomo's line. And so I spoke to the advocates about this section who believe it does something totally different than what the sponsor does, and at this point, I'm uncomfortable voting for this section without knowing what this section does. So my hope is that we can come back, restore civilian oversight in the conference committee, but for now, I'm yes on the amendment.
Senator Lee.
No.
Senator Castle.
Yes.
Senator Heddleman.
No.
Senator West.
Yes.
Senator Sidnor.
No.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
No.
Senator Huff.
Yes.
Chairman Smith.
I'm a no on this. So the motion carries. Okay. So are we done with this? Then we're gonna go to so that's now been adopted. Then we go to Vice Chair Wallstrecker has amendments, and we'll go to Senator Castle. Wait, sorry.
So here's my problem, is there's pieces of this amendment that I want to discuss before we adopt the whole amendment. So I don't know if Senator Wallstrecker has amendments to this amendment, or if
No, so we are now. So what we did was we adopted sections of that amendment.
Yes.
So we're now off of this amendment.
No,
But you
no,
want something
we
else
jumped
on
to
there.
the back half of this amendment. We didn't consider the amendments to the front half of this amendment. I have amendments to the first half of this amendment.
Okay.
You didn't start accepting amendments
good.
till we got halfway through it.
Castle, maybe we can jump through the rest of the amendments, and then as long as we can get back to Senator Castle's, because we've adopted all the sections, but if we can get back to his.
But we haven't
proposed-
adopted all sections. That's my problem. We didn't adopt anything on page 6 or 7. We didn't adopt anything. I mean, we've got plenty of big gaps in here that we didn't address, consider, or adopt. And there's,
No, we adopt.
we didn't. We did not adopt, for example, on page 6. I'm sorry, we did 6. I'm looking at 6.5. I don't know what the 6A, section 3105, which provides that all criminal offenses, there would not be a hearing in any criminal offense, whether there was a probation before judgment or anything, right?
Let him do his amendment.
Let him do his amendments?
Yeah.
Okay. All right, subject to the right to come back to this one, is
Of
that
course,
right?
of course. We'll consider.
Okay, I'll
Whatever
listen to
anyone's
Senator
got.
Wallstrecker's amendments. Thank you.
Yeah, just to be clear though, hold on. Chairman, one point. We did actually adopt the whole amendment because all the amendment language in this we did, but I think what he's saying is some language in the bill that was not reflective of this amendment he'd like to come back to. So I think, so after we're done with Chairman Wallstrecker, there might be other members that have amendments, then I think it would be proper to come back to that. But this amendment, we've all the amended language we have adopted, but we can come back to his. Thanks. Okay, clarify.
That's correct. All right, so we'll go with Vice Chair Wallstrecker.
Thank you, Mr. Chairman. So as I was talking to Senator Jackson this morning, I realized that there were a couple of things that were not included in his amendments that I thought could be helpful to clarify, that are technical and clarifying. So this packet of amendments does 3 things. The first makes clear that it's the law enforcement officer, not the chief, that can request the trial board. I think that's what we all intended. The second thing is that a finding of innocence is a factual finding. If you remember, Senator Bailey and I discussed this the other day. When we voted for the factual findings to be binding, I think we all were working under the assumption that a finding that the person did not do the act alleged was a factual finding. In fact, that was my answer when Senator Bailey asked the question. But I thought it could be helpful just to clarify that. And then the third thing is to determine what crimes provide you with the avenue to the hearing board. And this clarifies what crimes what crimes avoid the trial board and which ones still allow you to go to the trial board. That's all. That's all they do.
I think that it wasn't actually intentional to have the setup for the hearing board the way it is now in the bill. I'm also very comfortable with the way the bill is now, where we don't allow a second investigation where there's been a criminal conviction. I don't want to change that, and so I would like to reject this amendment in total.
So just so everyone's clear, we're on 768279/1.
This amendment restores
Thank you.
almost everything that we didn't want in the LEOBR. With the whole concept of the trial board, you're pretty much restoring that. The only thing that you're keeping is the final decision is still in the hands of the chief. Aside from that, you're putting the same process back in place. I don't agree with that.
Just to be clear, this amendment does not restore the trial boards. The trial board was work product from last Friday.
It restores the same procedure for getting to the trial board that is currently in the LEOBR.
Well, I don't support the current LEOBR. I'm glad we're repealing it. It doesn't make sense for I think we all assumed that when we were, last Friday, when we set up a civilian majority trial board, that whether it goes to the trial board or not was based on the officer's choice. If we allow the chief to choose whether to impanel a trial board, the trial board stands in the stead of the chief. A chief will never create a trial board if we allow that to happen. That was a typographical error that came out of the changes that we made last Friday. That wasn't a policy decision. No chief would ever impanel a trial board, period. What's the purpose of having the trial boards if the chief gets to determine who goes to the trial board? We didn't intend that.
The decision, policy is violated or not, but only where there were actually contested facts would there be, and I want to just correct this because nowhere in this bill is there a trial board anymore. We call it a hearing panel or a hearing board, because I'm hoping that we can get away from this belief that no officer can ever be disciplined unless they have a jury trial. Okay, this is an administrative proceeding. It's not a criminal proceeding. They're not entitled to a jury of their peers. We need to get away from that thinking. But no, this was about contested facts and a hearing panel to actually hear those facts in dispute. This was not about what we're trying to redo in the original LELBR and make everybody have this right to choose this trial board before they can ever be disciplined. I think that this changes the whole character of the intention of this bill. And again, I've already spoken. I would like the committee to reject this amendment. I'm happy with the bill as is. I would not be happy if we adopt this amendment.
Understood. Let's go to Senator Jackson, and then we'll go to Senator Huff.
So, Senator, thank you, Mr. Chairman. Senator Wallstreicher spoke to me this morning and says, in reviewing the bill, obviously I didn't review it close enough, and maybe some others didn't need as well. Look, our intent was, if I am the sheriff of the agency and there is an allegation brought up against a member of the agency, and we instruct the member of the agency, this is an allegation against you. This is against the policies and procedures of the agency, which holds this level of punishment, and the officer. I think we agreed to this last week. The officer can then either accept that punishment, or the notion, or the officer can say, no, I think I want to go to a trial. I want to go to an administrative board hearing. And so this is just correct. I don't know how we lost that, but the intent has always been that the officer would be able to say, I want to go to this hearing. Otherwise, I don't think we ever have a hearing. Why would me as sheriff ever call a hearing if I already, had made my mind up that, Officer X had done, something. So that's where I'm supporting the amendment. I just wanted to say that somewhere along the way, we lost that piece. And that I don't think there was an intent to get rid of that piece. I don't think we ever talked about getting rid of that. So.
Yeah, I mean, I completely agree. I mean, it's totally rigged to sit here and create these new boards and then say, well, the chief is the one that calls it. Well, the chief will never call it. The chief will just discipline you. It would be a completely and totally rigged system. So there was a motion, but I didn't hear a second. So I make a motion to favorably adopt the vice chair's amendment.
A little bit first.
It's been a motion, it's been seconded. Senator Castley, you got a question?
If I could, to the sponsors, I'm looking on 3105. It's on page 9 of your amendment of the reprint. It says, this is the provision that says, if requested by a law enforcement officer, the chief shall meet with law enforcement officer and consider any objections to the investigative findings and conclusions. And then if within 10 business days, the chief shall determine and impose discipline if the law enforcement officer requests a hearing. Let's see, if this is choppy. If the law enforcement officer requests a hearing under 3106 or order a hearing, okay, and the law enforcement officer may have a representative attend it, the chief or the chief's designee shall make a written audio of the meeting held under this section. So on the top of page 10, so we have this, the investigation's complete at that point, right? At that point, where 3105 kicks in, the investigation is complete, but they haven't yet had a hearing. Is that correct? Yep. So now we're sitting down with this meeting, which I don't understand, and then they're going to record this meeting, which I'm not sure why. There would be no reason to record a meeting where you're just saying, do you want a hearing? And then it says, if the chief shall provide law, the written shall include a summary of the facts. Okay, so, yes.
With respect, the capitalized wording is the wording of the bill as introduced.
Yes.
So that's Senator Carter's original language. The only amended language is the amended language on line 27 through 29.
No, I get that.
Okay.
I'm trying, and I appreciate that. What I'm trying to do is recognize that we've still got pieces that are just sort of extraneous hanging out here, and I'm not sure why they're still in there. We've discussed them. I'm not trying to hit anybody with fault. Excuse me. We're just trying to wrap up some loose pieces, because my view is that with Senator Jackson's amendment and your amendment, they pretty much, I don't really have further amendments. I mean, I have a big amendment, but yours have pretty much subsumed most of my amendment that I was going to propose. So I'm just looking at these last little pieces and seeing why
You're actually right about that. We can come back, but you're right. I think that's because we've had this amalgamation of like amendments over the course of the week. Some of these things got lost and left.
Yeah.
So this is something that you're talking about procedurally. This is superfluous and meaningless.
Right.
So we can strike that as we go through. We should do that and strike that because it doesn't.
Okay, and I guess that's what I'm trying to do, Mr. Chairman. Is I've been tracking these things through the many iterations and problems that are addressed in my very first amendment, which we never took up, which that's fine. I'm not complaining on that one. We have so many amendments coming up. But now we're carrying these through, and I'm not at what point we want to address these. I thought now would be a good time, but if you don't, okay. So I'm just looking at this process right here. Seems to me doesn't really fit under the new amended language. I don't have a problem with after the investigation, they sit down and discuss the punishment or the intended punishment based upon the allegations that are made. That seems to be okay, but there's no reason to record that. And then we go right into if a law enforcement officer requests a hearing, and that's appropriate. It's just that this meeting was originally a big deal, and I think now it's just there to say, hey, here's the charges. Do you want a hearing? here's how I see it. If you don't want a hearing, fine. And that's an appropriate meeting, but we've kind of made it a bigger deal than it needs to be. Just trying to simplify. So I would suggest, for example, easy one is the top of page 10, make a written audio or video recording of the meeting. All he's doing is saying, I want a hearing or not. Here's the chief saying, here's the charges, here's what I would give under these charges. You want a hearing or not?
Got it. So let's do this. Then let's roll, vote on the vice chair's amendment.
Okay.
Then we'll come directly to you, and we can do that one. I think it's just striking language, so it's no big deal. Senator Sidnor, and then Senator Hedelman.
Thank you. I did not second because I thought that we were going through each of these as we did the last one, but I have some questions about in section 3104. To me, it doesn't necessarily read as clarifying language. It reads more as of a narrowing language, because if you look at the section A1, it talks about an officer who has been convicted of or received probation before judgment for a criminal offense. But then when you look at the new language, it seems to be some restrictions. So you're looking at, one, those things had to have been committed in the execution of the law.
I was going to say, Senator, I think that's a separate, I'm confused. Where are you now?
3104. Since the senator is offered to move this entire amendment, I just want to make certain I'm understanding what it is that we're moving, because I thought we were going to be going through these similar to what we did the last one.
Let's that's fine. We can do it by piece. Let's do it by piece. It's easier to track that way. Senator Hedelman, go ahead.
Same section that Senator Sidner's on.
Okay, got it. So let's take the first part first under consideration, and then we'll keep moving.
Do we want to start with 3105, or
Yes.
I guess the page before that 3104 has new language too, but
Yes, just explain that.
I think we completed the discussion on 3105, if you want to vote that, and then we can go.
Yeah, let's do that. Yeah.
Okay.
We have the 3105.
Sure. So 3105 provides for the meeting with the law enforcement officer, or between the law enforcement officer and the chief. That's the meeting where the law enforcement officer can provide objections, additional evidence, mitigating circumstances, and then after that meeting, the chief would be required to determine and impose disciplinary action, if any, to be taken against the law enforcement officer, or if the law enforcement officer requests a hearing under the next section, order a hearing under that section. I would note, just before the committee adopts it, in line 25, the language after number 1 should probably say subject to item 2 of this section, just to clarify that the chief's imposition of discipline would be subject to any election by the law enforcement officer to have a hearing. This is page 9.
Lines 27 through 29. All right, so there's a motion. Has it been seconded? Yeah. All right, so we do a roll call? Or, let the officer decide. This is just, so the amendment, we're parsing these out now, and we're on page 9, lines 27 through 29, and this allows the officer to decide to go to that 3-person board with 2 civilians, 1 officer for the hearing, instead of, because right now it's the chief can only decide to go to do that.
We have to adopt this first, then they'll come back to what you're saying.
Yeah, got it.
Adopt this first, then they'll come back to yours next.
That's a really vague term.
Adopt the amendment that instead of the chief calling the hearing, the officer will be the one that requests the hearing. That's the vice chairman's amendment.
All I need to know is what lines, give me a page and line numbers that
Yeah,
we're
so,
adopting, and that's the easy way to do
page
it.
9, lines 27 to 29.
Thank you.
The option to request a hearing board, not the chief. Is that what you're, chief doesn't have that option, right?
The bill's drafted, it provides that if the chief determines that there's a disputed issue of fact, then, correct. Right, it's.
Got to
that's-
make that determination.
That's correct, it's solely with the chief. Or if the chief decided that there were no issues of disputed fact, could impose discipline. What this amendment would do is,
It's up to the law enforcement officer.
Right,
To make that call.
exactly.
Okay.
Vice Chair Waldstraker,
Yes.
Senator Lee,
No,
Senator Castle.
Yes.
Senator Huddleman,
no,
Senator West,
Yes.
Senator Sidnor,
Yes.
Senator Jackson,
Yes.
Senator Bailey,
Yes.
Senator Carter. No. Senator Huff,
Yes.
Chairman Smith.
Yes.
Do we go back to 3104? 3104 is what
So the motion carries. All right, so we're just gonna go, so what was you have a question on 30104? Hold on, so we're gonna stay on 3105 real quick with Senator Cassidy, then we'll go through 104.
I
Senator
just
Cassidy.
figure and wrap up 105. Is that okay? So my motion is to delete page 10, lines 1 and 2, and also page 10, lines 7 through 10. Actually, I'm not sure. Let me take that one at a time. Page 10, lines 1 and 2.
So this is eliminating the requirement to make written audio or video recording at the meeting held. This is the
Yeah,
superfluous
I just think
meeting.
it's an unnecessary burden, because if he asks for a hearing, we're going to record the hearing. There's no reason to record that meeting.
Thank you, Mr. Chairman. I have the recollection that several days ago, we passed an amendment which struck everything relating to a meeting. Am I wrong on that? I am.
We missed a couple pieces, but yes, that was the intent,
What was the intent?
to get rid of that, the meeting, the secondary meeting. It's
The
not
whole
this.
meeting?
Yes.
Right, so if that's the case, why do this deals with the meeting. If we've already gotten rid of the meeting, why are we?
I
dealing
think that's
with-
right.
What?
I agree with you.
Yeah.
This is a drafter's error.
So this is just about the second meeting? Right, okay.
To strike 3105?
Yeah.
No.
No.
Page,
Just
page 10. Page 10.
trying to pull a fast one on us, eh? Yeah, we're not that tired. Just lines 1 through 2.
What else you got, Bob?
Hold on. Yeah, well, he's working it.
Jumped me when I said pull the meeting back. I thought I was going to start a mutiny, so I backed off. So, I mean, the motion. We did it. Okay, so D is off. Okay, and then I'm ambivalent on page 10, lines 7 through 10. I'll move to strike those, but I would be very open if someone thinks that that's a bad idea. It just seems to me that if the officer can accept it, in which case, why do we need this chief to go through all the rigmarole of writing up a summary of the facts? Because he's going to just turn that over to the hearing board and say, give me your summary of facts. So he's already said you were charged with X, and the officer says, you're right, okay, we're done. Now, if the officer doesn't accept that, then we have a hearing board and we determine all the facts.
Like you say, I'm agnostic on this one. I defer to the law enforcement officers. I mean.
You're on page 10, 7 through 10.
The amendment.
This is in that meeting, the meeting before the hearing board.
I'm just going to say that I don't know that we need to, this is not such a technical issue for policing that we've got to defer to the law enforcement officers. I mean, my feeling on it is, even though you've completely restructured everything that I intended, my feeling on it is that there should always be a record made of any part of this disciplinary process, so keep the record. What's the problem with that?
I'll roll with you on that. That's fine by me. I just asked them because they know the process, they have actual, on the ground experience with this. I just wanted to get to more insight. So I'm fine with keeping it. I don't care.
I'm sorry, I can't hear what you're
Just
saying.
Defeating the proposal to strike lines 7 through 10. Just keep it.
Okay.
All right. So motion's withdrawn. We'll keep it. Okay. Vice Chair Walker.
Okay. You want me to go? Yeah. Oh, okay. So I guess we could do 3104. So 3104 was a little unclear to me because it allowed any crime at all, any conviction at all, to bypass the hearing board, but without any limiting factor about what crimes are in and what crimes are out. So I just did my best job here to try to make it relevant to the person's role in law enforcement. And so, you want to include crimes of moral turpitude. So, but that doesn't have apparently a really easy definition. So, so we tried crimes that bear on the law enforcement officer's credibility, integrity, or honesty. And those are the crimes for which the chief the officer, as we just took that amendment, is not allowed to go to a trial board, or a hearing board, I should say. It allows the chief to bypass with that and impose discipline immediately, which as he should, or she. I think that's exactly the right thing to do. So it was just an attempt to clarify what we meant by crimes.
Jeff, I'm not sure how you characterize what you just did as attempting to clarify, because I think it was really clear. It said crimes where there's been a conviction or probation before judgment, which we know in Maryland means that there's a guilty finding that's underlying the probation before judgment, that there would not need to be a relitigation of those facts because it's already been determined by a court of law under a standard of reasonable doubt, beyond a reasonable doubt. And so I'm going to stand by my belief that we don't need to alter this section at all. First of all, if whatever the crime was doesn't constitute a violation of any of the policies of this agency, then it doesn't apply. Then there's no discipline that has to happen. And so to do this, once again, this is another section where you are rewriting the Law Enforcement Officer Bill of Rights. Why don't we just call this the FOP version of police discipline outside of the Law Enforcement Officer Bill of Rights?
All right. I'd like to second it. I mean, that's what we've been talking about constantly, is crimes of moral turpitude on this. It makes sense. So we're trying to, again, put together sensible policy. And just a distinction over and over again about how we deal with people in these crimes. I have fought this committee so many times talking about PBJs. Normally, you're on my side on this. PBJs, not treating them as conviction. Expungements. All these things, people getting rights to hearings. All these things, whether it's people on the police side or the other side, I think it's fairness. And that is a common sense amendment. I second it.
Sheriffs have said that they don't like their hands being tied when there's a crime, any crime. No. Even they have said. So my point is that the only group of people in the state of Maryland that want this is the FOP. So I feel like this is just doing that bidding.
No, there's more than that too. So, but let's face it, the only people on your side, your side's the ACLU. That's who your side is. The ACLU, who is now against due process, and now against expungement, and now for bad acts and all these things. So the contradiction here, just to be honest, to sit here and have to defend expungement, have to defend due process rights, have to defend PBJs, let's have some damn consistency here.
So
everything. Hold on. On the people who have come in this committee on criminal rights, time and time again, I have consistently argued, and you are on my side on those. With police, you are double standard constantly tonight. When it comes to expungement, when it comes to PBJs, when it comes to bad acts, when it comes to due process rights, you and the ACLU have done a complete 180.
Let me tell you how that's different. Let me talk about how this is different, because we've talked about this before. Now, the reason, especially for things like non-convictions and PBJs in Maryland, is because people that were tainted with the stain of a criminal conviction were precluded from jobs and housing and education and loans and opportunities to advance themselves in life. There is zero evidence that there's been any problem with law enforcement officers that have even been found sustained. You all like to keep saying guilty, guilty, guilty. Less than 0.5% or so ever get in a criminal court anyway. So we're talking about administrative proceedings. And so there's no evidence that they've had trouble continuing to either work in their own agencies or in other agencies if they have these things. So there's no comparison between people that are just trying to get an opportunity to get out under a stain of a conviction and just saying that if there has been a criminal finding, that there's no need to relitigate that fact if you work in the agency. That's all that this is.
I just have a quick question for Jamie. What about a domestic violence PBJ? Do you have to investigate that separately if this provision goes through?
Sort of the subject of a question that I think came up the other day.
What is the crime of domestic violence? That's not a crime. It's an assault. There's no crime of domestic violence.
Right. So
would that be a separate?
It's an assault. Yes. Crimes? Stop saying a crime of domestic violence. It doesn't exist. It's not in the law.
Okay, so it's assault.
What's the answer? The answer is yes. You have
Because
to
an assault,
open
a
it up
PBJ
to
is not a conviction.
investigation again.
We'll do this one person at a time, all right? So we're going to go, thank you, Senator Lee, for the question. We'll go for the council to respond, and then we'll go back to Senator Hedelman.
So I think it would determine or depend on whether that was considered to be a crime that bared on the law enforcement officer's credibility, integrity, and honesty, which is what's specified in the amendment.
Order, like a violation of a protective order, would that?
Would turn on whether that was considered to be a crime that bared on their integrity, credibility, and honesty.
But if you're found guilty, if you're subject to a protective order because of domestic violence and you're a police officer, you lose your right to possess a weapon. And if you violate that, now you're committed a crime. And so once you've lost your right to use to possess a firearm, you basically cease to be an active police officer.
All right, a couple things. So first of all, it is my belief that domestic violence is an offense of integrity, reflects poorly on you as an officer, and would be fireable and would avoid a hearing board. And I think the officers who serve on our committee have testified to that previously. And so I don't think that's in question. And so a couple things that were said earlier that I just want to clarify. So the first thing that was said was that it has to be both a crime and a policy violation of the department in order to avoid a hearing board. As drafted, that's not correct. It is only a crime. It does not have to also be a policy violation. The second thing that was proffered was that somehow this language came from the FOP. It did not. I drew this language from something I'm familiar with. I took it from the ABA Model Code of Professional Conduct. It doesn't come from LEOBR, which I will join the sponsor in wanting to repeal. I pulled this language directly from the Model Code of Professional Conduct. We can be disbarred if we engage in conduct that reflects on our honesty and integrity. And I literally just stole the language from the ABA and threw it in here. And then the third thing is, there's no way, I mean, the whole purpose of this amendment was that there's no way we can mean that all crimes avoid the hearing board. So behind me is the transportation article. It's right there. Every violation in there, almost every violation, is a crime. It's a misdemeanor. If you are convicted, you are guilty of a misdemeanor. If you speed, you are guilty of a misdemeanor. And so as drafted, if you get a traffic ticket for speeding and you are convicted of going 60 in a 55 on Route 50, you can lose your job. There's no way that that is the policy result that was intended here. So all my attempt was not to restore anything, was just to provide some logical, simple bounds so that every minor criminal act, which none of us even consider to be criminal acts, do not get someone fired from their job. That's all.
This motion's been seconded. We'll roll it.
That would be 3104, that's page 6. The amendments to line 21 on down. Correct.
I'm also looking on the reprinted page 8, line 28. Wouldn't that amendment also extend to 28 through 31? Seems that your amendment would be the same amendment to that section as well.
I think so, yeah.
To page 8, lines 28 on down then?
I'm just making that suggestion to the maker of the amendment, since it would seem to be, it would be consistent.
Yep, I think that's right.
Okay, I would second that.
That would be consistent between the two provisions if it did.
Right, otherwise there's a conflict without that. So I second that motion if it hasn't been.
Vice Chair Wildstreicher.
Yes.
Senator Lee.
No.
Senator Castley.
Yes.
Senator Heddleman.
No.
Senator West.
Yes.
Senator Sidnor.
No.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter. No. Senator Huff.
Yes.
Chairman Smith.
Yes. The amendment carries. Sure. Since we're staying in the same section.
Page 8, line 21 through 27. I believe in a previous edition we struck this. There was no reason not to give the law enforcement officer the file.
Adopted earlier today. So that wouldn't be reflected on this amendment only because those.
No, I understand. I'm not trying to. It just seems to me that we. Well, I would just move that we strike 21 through 27. That they. They're required to give them the copy of the investigative file. Don't give them an option, just give them a summary. That's what we, in a discussion last time, the officers on the committee said, no, you would get the full investigative file. So we don't need to abbreviate that. Give them the file. So the motion is just to strike lines 21 through 27.
Right. So earlier this session, or sorry, earlier tonight, the committee actually adopted that amendment in Senator
Okay, so it's already been
Jackson's.
made? Okay, and then
Right.
maybe this one's already been made too, Jamie. Page 9, lines 1 through 6, it's similar. Seems like it's in sort of dead letter. This is the provision that says the officer would then provide written objections to specific findings of fact.
So the provision that says that the chief.
No,
on
it's page
completion of-
9, lines 1 through 6. Give the law enforcement officer the opportunity to specifically identify in writing any contested issues of law or fact related to proposed disciplinary action or factual conclusions supporting the determination that the law enforcement officer committed the offense or offenses for which the law enforcement officer is subject to disciplinary action.
So that's after the investigation is complete, or excuse me, before the
That's
chief
before
or
the hearing.
designee can impose any disciplinary action.
Yeah, there's just no reason for to tell the charged officer, you have to give us a written statement of what you disagree with here. You ask for a hearing and you have a hearing. I mean, what this is saying is the chief's going to give you the record, and now you're going to look at that and say, well, here's what I object to, or here's the
I
facts.
think under the initial scheme of the bill, that was just given to allow the officer to have just something else on record. So you're right. I think you're absolutely right.
Yeah, it just does, it no longer fits with the scheme here, so I just moved to strike that section.
You're not, what exactly are you striking?
It's that you would not normally tell somebody in an administrative hearing who's been charged with, an employee who's charged with a disciplinary violation, you would not then say, well, you have to give us a written statement of what facts you would disagree with. You would say, do you accept the punishment, the discipline? If they say no, then you say, okay, well, let's have a hearing. And you have a hearing. You don't tell them, well, what part of this do you disagree with?
So
They
this
have
is a
right to
remnant
just-
from the initial scheme in which we had just the sheriff making the decision with a hearing officer, and it was the opportunity for that officer to give some sort of written statement. So it just doesn't fit under the scheme anymore, as Senator Gaston said. It's just a remnant. I think you're probably right to strike it. Is everyone okay with that? All right, good.
I'd like to get, it keeps coming in or out, and it's on page, there shouldn't be any opposition to this. The language appears on page, look on page 5 of the reprint. It says law enforcement officer does not include, and then it says, line 9 says the police chief, I'm sorry, measure of the appointing authority. We were trying to, Jamie, we talked about language to change that to senior law enforcement official as opposed to police chief. Did we do it there or somewhere else? Our problem was it wasn't clear that it doesn't include the sheriff. It's the chief, the police of chief, I'm sorry.
So, Senator, are you I guess, in your amendment that was in the packet, what your amendment had done was it actually excluded the head of a law enforcement agency from the definition of law enforcement officer.
Okay, I'm sorry, that's right.
So that would be on page 5. In line 9, currently the police chief of a municipal corporation is excluded from the definition of law enforcement officer. And I believe your amendment struck that and replaced that with the head of a law enforcement agency.
Yes. It's just because there's more, it's just broader. It doesn't, basically, see, this doesn't apply to the top cop.
I like that.
So that's my amendment.
Does everyone understand what the amendment is?
So it's on,
Okay.
on page 5 of the reprint, line 9. So we're saying what these procedures don't apply to like a sheriff or a chief of police. They're the top cops. But the way this is written, it's not clear that it doesn't include a sheriff. It says the police chief of a municipal corporation, so we're just expanding that to include both that police chief, but also sheriffs. And so the new language would be, what was it, Jamie?
The new language would strike line 9, which says the police chief of a municipal corporation, and instead say head of a law enforcement agency.
That's my motion.
I'll second that. So essentially, this captures more people and removes them. Well, it doesn't remove them because they're never part of the LEOBR anyway, but the initial LEOBR.
It just, there's an inconsistency in the current
I know.
LEOBR where in some cases it looks as though chiefs are actually removed from the LEOBR, but in other cases they're referenced. So there's actually a minor inconsistency in the current LEOBR about that.
Yeah, I should remove that out. Okay. Okay. Great.
So I don't know if someone's going to move Senator Wallstreicher's amendment.
So that amendment will carry. I'm sorry. Go ahead.
And now we need to move both Senator Jackson's and Senator Wallstreicher's amendments as amended.
Been going along, so we're done.
We don't have to take them as a whole, we've been taking them individually.
Yeah.
They're on the front end of your packet. They are in individual form, not the reprint.
But we've been taking them as we've been going on.
There is one there.
All right. Vice Chair Wallstreicher has another amendment.
So the last one is just what I mentioned earlier about what the committees will seem to be on Friday, and just clarifying that. So on the bottom of page 12 of 17, underneath line 31, the first sentence there, a chief may not alter findings of fact determined by the hearing board. That's Friday's work product. That's not new language, even though it's underlined. That's Friday's work product. And I think what we intended that to mean is that a finding that the alleged act did not in fact occur was a finding of fact that was then bound under what we decided on Friday. And if you recall, Senator Bailey asked me that on Friday, and I was like, yeah, I'm pretty sure that's what we all mean, and everyone seemed to nod in agreement. But I thought if we're in kind of a clarifying mood, it couldn't hurt but to put that in text, to avoid any ambiguity. And so that's what number 2 is, below line 31.
To be honest, I mean, it seems just clarifying. That's what my understanding of what it was in the first place.
And the discipline is completely up to the chief if there is a finding that the officer did in fact do what is alleged. As we intended. Facts, and if the facts don't indicate that the person did what is alleged, then those findings of facts would be bound as we intended in sentence number 1.
All right, that's fine.
Senator Carter's a no. So is anyone else opposed to that? Okay, so we want to know Senator Carter's a no.
So can I just ask, so there's plenty of other small amendments in here that we haven't covered in your amendment, Senator Wallstreicher. Are we going to bring them in? I mean, I'm looking on page 12. You've got hearing officer rely on hearing officers. The hearing board may rely. Are those part of the amendment?
So those actually, in order to have Senator Waldstreicher's amendment make sense, I did have to import some of what the committee had already done. So that's what that's reflective of is those
so
changes.
that's already in here.
Correct.
Okay.
And then at the end, I'll make a motion for just to allow council to make conforming changes so that everything's consistent. We can just do that, and then.
Oh shit! This is mind numbing.
Can I just ask a procedural question? Are we done? Or there's not going to be any vote on what we've just done, is there?
Well, we've been voting them on now as we've been going.
And there's no vote on the whole package?
Yeah, we're going to on the whole bill.
Right.
Yes. So unless there are any more forthcoming amendments, Senator Sidnor.
Yes, I had submitted Amendment 5039291, which was a reporting requirement that we have yet to take up.
Distributed to the members either by it was distributed by email to the members
On Monday at 6:18 p.m.
on Monday at 6:18 p.m.
/1.
Correct. It's 503-929/1. It was on Monday just after 6 p.m.
Okay.
So what this provides is that this adds a new section that provides that if you go to page 16, this would add a new section that would provide that for each investigation of alleged misconduct or disciplinary action against a law enforcement officer, the chief would be required to transmit to the Governor's Office of Crime Prevention, Youth and Victim Services, which was formerly known as GOCAP, information about the general description of the misconduct or disciplinary action, and if applicable, the reason for the disciplinary action. Also information, if known, about the age, race, and gender of the law enforcement officer who's the subject of the investigation or disciplinary action, and if applicable, the individual who reported the alleged misconduct. the date and location of the misconduct, if applicable, the date of the disciplinary action, the agency employing the law enforcement officer when the misconduct or disciplinary action occurred, and the result of an investigation that does not lead to disciplinary action. Then, each year, on or before December 31st, the Governor's Office of Crime Prevention, Youth, and Victim Services would be required to report to the General Assembly on the information collected under this section.
Can we just do the report on crime?
So does this have identifying information? So is it anonymized, or is it identifying information? Like the law enforcement officer who is the subject of the investigation. So I guess that identifies the officer.
The point of this was because we kept hearing about how LEOBR was put in place initially to protect black officers. There was some concern that when chiefs came down and maybe they were unfairly disciplining people, we wanted to see by this reporting what was going on. So I don't need a name so long as we have certain demographics to kind of see what's going on in the chiefs, so we wouldn't have to go through a lot of public requests. It's all right there in an annual report.
So just to flag it, and to what Senator Sidnor just said, the amendment doesn't require the name or identifying information about the officer other than that demographic information. But if there's a concern about that, there isn't anything that necessarily prohibits that, so that may be something that.
Actually, I like the idea. So, I mean, but if you want to put the clarifying language in,
Move it.
To protect the officer's name, we should also protect the complainant's name who may not wish to be identified.
yeah, that's true. Yeah,
Okay,
yeah.
yeah. That sounds good.
No, so you're not reading the preface to that. So if you look at Arab 1, if known the age, race, and gender of, if applicable, the individual who reported, it's being modified.
But in substance, I agree with you that I think you don't want to put the individual who complained and send it up, and then you don't want to do the officer. I think if it's go cap, and you get generalized data on race-based traffic stops. It doesn't give you the officer that pulled over the person and the name of the person they pulled over. You're just, go cap's supposed to be generalized data.
I'm trying to make it useful. I almost feel like we should be telling GoCap to come up with a form for this to be reported on, because if it's sort of an anecdotal, I mean, how are you going to? There's got to be something that they create a form so that we can say, is this a vehicle issue or a race complaint or something, so we can look at stuff. Otherwise, you have this mash of otherwise you get all this words that's hard to. We need it computerized, right?
Senator Lee had language in her old bill when she had the SWAT reporting that collects information in that way, as the council advises us. So we could just borrow that language that says they shall develop a uniform method of reporting.
Yeah, so that it to achieve these objectives that he's put in here, but and they just submit this form for disciplinary actions. I'm fine with that.
Favorable is
on Sidnor's.
If we get that clarifying language, we'll give you the latitude to just develop that language. That's fine. Yeah. It's been seconded. Let me go ahead and All right, we'll just do, everyone's okay with that. We'll leave it open. Just leave it open for Friday. Everyone's okay. Okay, further amendments.
All these amendments, though. Give me just a second.
Okay.
Was the fact, and I guess, Jamie, the easiest way would be to go to your amendment 268076-1 that we got, I think, on the 17th, 16th or 17th. So I think in making great, when you get there to the reprint, Jamie, it would be page 9, and we'll go down to section 3106. So just to explain,
Go ahead, explain, James, we're going to print it out so everyone gets it. So
okay.
you can go ahead
So
and...
just to explain what is happening here is, and what we have left out of this bill completely, is what happens when an investigation is started on an officer, right? That officer's working in uniform, he's carrying a gun, he's, all of a sudden, he comes into work and he realizes that somebody is actually investigating him. It causes quite a lump in your throat when you realize that that is happening. There's a small section here that we had in on that amendment, I guess it was an amendment, that covers that. And it simply says, that the complaint against the officer under interrogation is informed that that he knows. Then he knows who the investigator is. He will know that that each individual will be present during an interrogation. Before the interrogation, the law enforcement officer under investigation shall be informed in writing of the nature of the investigation. The law enforcement under interrogation, if he's to be under arrest, what will happen? If this is absolute serious nature, or if it's not a serious nature. It spells out exactly, reasonably, what will happen during that interrogation for that officer. I don't think it is something that's unrealistic. I think it falls right into what we would expect as you worked as a law enforcement officer.
Well, I don't have the amendment, so I haven't seen it. All I have is the senator's explanation. But we're dealing with an administrative proceeding. We're not dealing with a criminal proceeding. So, for example, in the original Law Enforcement Officers' Bill of Rights, there were provisions that required officers to submit to interrogations, required them to take polygraph tests. I don't think we've incorporated those provisions into this. So, since this is merely administrative proceeding, does the investigator have the right to compel the officer to submit to an interrogation? I don't think so. Not with what we've got here now. Am I right on that?
If they do have an interrogation, and even the amendment that Senator Jackson had yesterday had the first half in this, yeah, of course. So that, and it talks about there was nothing in the original law that talked about compelling that, or like a part of it that forced to compel them to polygraph, but the interrogation said, if you do, these are how, the whole interrogation section was, they have right to counsel, how many days they have in. If you do it, you can't threaten like, hey, if you don't tell me this, you're fired. There was a lot of stuff in that interrogation section which is still relevant.
I understand, that was in the original LEOBR.
Yeah.
But I don't think it's ever been included in the bill that Senator Carter filed.
It wasn't in Carter's bill, but it was in it was in the amendments. One of the amendment sections we did yesterday had the first half of it was in there.
Well, let's ask Jamie, because, Jamie, did we ever put anything in, have we ever agreed to an amendment which would import into the current into this proposed bill, language that would require a law enforcement officer to submit to an interrogation, set forth standards of interrogation, whether or not the person has to submit to polygraph tests and the rest?
Jackson's amendment from yesterday.
But he withdrew it.
Right. There were provisions in there that provided for polygraph,
Right.
drug testing, and interrogations,
But
but so far the committee hasn't adopted any provisions relating to those for.
Okay.
The current law, if you strip that, it's this. If you strip that, without that, there's no standards for that anymore, for the requirements of. So there's no. So they can. So if they want, they can polygraph, drug test, interrogate. No time for counsel. They can go back doing all that how they want, willy nilly. Because the original LEOBAR is a guidelines and set of protection or guidelines for how you deal with police officers, and so the whole interrogation section is currently 3-104. 3-104, which is now gone, starts off interrogating, investigating a police officer. And it goes all the way down. All these sections are now gone in the law.
That's my point. That's my point. They're gone.
They're gone in that.
They're not part of this bill.
They're gone in that now you can, without these, the right to counsel part is gone. The threat, you can threat, transfer, dismissal, or disciplinary action. You can now do those things to them.
On what basis?
You had to, before, keep a record of interrogation. That's gone. So, I mean, there's a lot of stuff in here that we're wiping out.
Council will clarify something. Go ahead.
So in the labor and employment article in section 3702, it does generally provide, so this is a little bit of an ambiguous question about whether or not, at least in the context of polygraph, it could be required. So it does provide that an employer may not require demand as a condition of employment, prospective employment, or continued employment that an individual submit to or take a polygraph exam. However, individuals defined as law enforcement officers are excluded from the requirements of that section. So,
Police officers to submit to polygraph tests.
no, the law independently prohibits the use of polygraph, but it doesn't prohibit it for law enforcement officers.
Interrogations, how they can do them, they can counsel, polygraphs, how they can treat them.
Right.
There's a lot of stuff in here that's
So,
wiped
is there
out.
a motion?
That's my point.
This amendment.
Motion to adopt the amendment.
I don't have it. Do you have?
It's actually. So actually, the amendment number that you referenced, Senator Bailey, was from a draft amendment that I don't think that it's a formal amendment that was ever distributed.
468075.
Right, and you do have those provisions in your amendment.
468075, and as a substitute to Senator Bailey's motion, it would be move page 9, line from 3106. This is a Castley amendment. It's 468075. Amendment 468075/1, and it's page 9 of the reprint. Okay, so page 9 of the reprint. I'm going to go slow till you get there. Page 9 of the reprint, it's halfway down the page, it says 3106. It's hidden. It's hard to see. It's on the left edge. It's 3106. You see that? It's halfway down the, okay. I would move from that point right there, that page, the next page, and to the top of the next page, up to letter, which is marked there as letter, was K, strike to J. Excluding, of course, what's been deleted from the amendment. There are brackets on section B.
Okay, the motion's been made. What is the motion?
Yeah. So we're looking at the amendment that's 468075?
I don't have.
Let me see if I have another copy. Here you go. There's another copy, John. Make sure this is the right one I'm giving you. 468075.
Is
There
it,
you go.
is it on, it was sent out,
Let's get this done.
I got it.
Oh, roll call. It was for the favorable. It's been seconded. Roll call.
Vice Chair Wadstriker.
No.
Senator Lee.
No.
Senator Castley.
Yes.
Senator Heddleman.
Just to be clear, this restores basic rights that an officer has during the investigation, because he is subject to interrogation. He's subject to interrogation in the police station, and it just establishes what the officer's rights are during that process, the administrative interrogation. So I vote yes.
You guys. You're sitting here complaining. It's your bill. We're only here because it's your bill. All right, hey, you guys gotta. No, you're being rude. Hey, so we're literally in the middle of roll call.
Senator Heddleman.
No.
Senator West.
I'm gonna pass. I gotta read it.
Senator Sidnor.
No.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
No.
Senator Huff.
Yes.
Senator West.
I guess so, yes.
I'm a no. All right, the motion fails. Are there any further amendments to the bill? All right, so
No amendment to the bill, but from a procedural standpoint, are we doing the bills that we set up for tonight? Do we have the prints for?
no, we're just going to do this. So the bills are going to be, we'll have them perfected, ready for us when we come back on Monday. No, which ones? We're doing them tonight?
Damn.
Do you want to make that amendment, or you want me to make it? Okay, we're going to take a 2-minute break to... Yeah, no, he's... Give it a 2-minute break. 2-minute break, 2-minute break, 2-minute break. We're taking a 2-minute break. All right, great. Now we're missing council. Okay, great. So now, no further amendments. I've got one last, for the package, to conform to the rest of the package, to change the title, to make sure that it matches. Everyone okay with that? Okay, great. That's adopted. So then, just changing the title so that it conforms to the rest of the package. All right. Now, so then, the bill as amended. And the motion is for favorable, subject to further technical, stylistic, and conforming changes. It's been seconded. So roll call.
Vice Chair Waldstraker.
Yes.
Senator Lee.
Yes.
Senator Castley.
Pass.
Senator Heddleman.
Yes.
Senator West.
Pass.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Pass.
Senator Carter.
Pass.
Senator Huff.
Pass.
Senator Castley.
Yes.
Senator West.
Yes.
Senator Bailey.
No.
Senator Carter.
This is no longer my bill. I will vote yes on the bill because it's a smidgen of an improvement over the prior Law Enforcement Officer Bill of Rights. But we still should call it the Law Enforcement Officer Bill of Rights because that's what it is. So I'll vote yes because it's a slight improvement, but it's not a repeal.
Senator Huff.
No.
Change my vote to no as well.
Chairman Smith.
You want to change your vote? All right, I'm a yes. All right, look, everyone. I just want to say thank you all for the endless work. This was a really, really tough process. I just want to let you know that we all appreciate the hard work and the input and the dedication you put into this process. A lot of people took tough votes. But I think just never forget the fact that we're making progress here. And when we get to the floor, we'll have something we can defend and make sure that it gets into law. So have a good weekend. Thank you all for an extremely tough week of work.
When are we coming back?
We are coming back on Monday. Hold on. So here's what we do. All right, let's do this. We're going to come back on Monday at, when is the first floor session?
6 p.m.
So let's come back at 11, and we'll 11. Does that work for you? Okay. No. Just not for voting, but for work, like a work session on the last bill. Okay, got it. So we come back at 11 to workshop use of force. We get it in a good spot so that when we come back before floor to vote, we're going to vote before the floor on Monday at, what time is?
Sometimes it's at 5.
Can you guys get here at? What about 5? Can you guys get here at 4:30 for voting as well?
We got executive noms at 5.
I was gonna skip that.
I mean, if you're going to vote, can you vote at like?
We need like an hour to vote.
Yeah. Okay. Can you vote at 4?
Can people get here at 4? 4 o'clock? Can people get here at 4? I can do that. I can compromise. All right, let's do 4 o'clock.
Is 11 o'clock in person or virtual?
We could do virtual, actually. Let me figure this out. So, do you want to do 11 for a workshop?
If it's just a work session, it can be virtual.
So, 11 workshop can be virtual. And then we'll be here at 4 o'clock to vote. Got it.